On February 3, 2018, Denny DeLucio, Sheriff of the RTC of Makati, served the order granting ex parte application for preliminary attachment of Dinggoy against Dudong. The order, together with the writ, was duly received by Dudong. On March 1, 2018, the sheriff served upon Dudong the complaint and summons in connection with the same case. The counsel of Dudong filed a motion to dissolve the writ. Can the preliminary attachment issued by the court in favor of Dinggoy be dissolved? What ground or grounds can Dudong's counsel invoke? The answer is yes, the preliminary attachment issued by the court in favor of Dinggoy can be dissolved, because the enforcement thereof was improper. In Torres et al. Versus Atsatin, the Supreme Court ruled that once the implementation of a writ of preliminary attachment commences, the court must have acquired jurisdiction over the defendant, for without such jurisdiction, the court has no power and authority to act in any manner against the defendant. Consequently, any order issuing from the court will not bind the defendant. It is thus indispensable not only for the acquisition of jurisdiction over the person of the defendant, but also upon consideration of fairness, to apprise the defendant of the complaint against him, and the issuance of a writ of preliminary attachment, and the grounds therefore that prior or contemporaneously to the serving of the writ of attachment, service of summons together with a copy of the complaint, the application for attachment, the applicant's affidavit and bond, and the order must be served upon him. In this case, since copies of the complaint and summons were served after the writ of preliminary attachment was served upon Dudong, the writ therefore was improvidently issued, the writ of preliminary attachment may be dissolved. The alternative answer is yes, the party whose property has been ordered attached may file a motion to quash the order by filing a motion in court, in which the action is pending before or after the levy, under Rule 57, Section 13. The other grounds are the following. Writ was improvidently issued. A counter bond had been posted by the defendant. The attachment bond was insufficient. If Dudong posts a counter bond, is he deemed to have waived any of his claims for damages arising from the issuance of the order and writ of attachment? The answer is no, the posting of a counter bond does not amount to a waiver of his claim for damages arising from the issuance of the order and the writ of attachment. The counter bond and a claim for damages pertain to two different aspects in the issuance and implementation of a writ of preliminary attachment. A counter bond posted by the person against whom the writ of preliminary attachment was issued does not answer for damages on account of the lifting of the attachment, but for the payment of the amount due under the judgment that may be recovered by an attaching creditor. The counter bond stands in place of the properties so released. On the other hand, a claim for damages by the person against whom the writ of preliminary attachment was issued is governed by Rule 57 Section 20 of the Rules of Court, which states that an application for damages on account of improper, irregular or excessive attachment must be filed before the trial or before appeal is perfected or before the judgment becomes executory, with due notice to the attaching party and his surety or sureties setting forth the facts, showing his right to damages, and the amount thereof. Such damages may be awarded only after proper hearing and shall be included in the judgment on the main cause. Considering that the rules of court provided different purposes for the filing of a counter bond and the filing of claim for damages, Dudong's posting of a counter bond cannot be deemed a waiver of his claim for damages. For more discussions and similar videos, please like, share, subscribe and click the notification bell.